So good morning, everyone, and good evening. I am Deepika Yadav, coordinator for the Digital Trade Alliance, and I would like to welcome you all to today's webinar. Digital Trade Alliance is a cooperative effort of 11 digital rights and consumer groups from Global South and Global North. The Alliance has share ideas, collaborate, and produce needed research to inform the debate at the intersection of digital rights and digital trade issues. And we have been coming out with some very relevant research. And today, we would like to share with you our new research on AI and source code. This research has been commissioned by DTA and carried out by Joshua Tan. You can find this report. You can find the report on DTA website. Please check out the link to the website and the report in the comment section. Now, I would like to take this opportunity to introduce to you our speakers. We have an excellent panel of experts with us today. Please welcome Joshua Tan. He's the author of the report. He's the co-founder and executive director of MetaGov. He's a mathematician and computer scientist at Oxford, whose research focuses on applications of higher mathematics to design of intelligent systems. We also have with us Professor Christina Arian. She's the associate professor at Institute for Information Law at University of Amsterdam. Her current research agenda focuses on governance of transnational digital technologies and global data value chains from the perspective of European law and international economic law. Dr. Arian frequently provides expertise to the European Parliament and frequently provides expertise to commissions, the Council of Europe, the OECD. She wrote a wonderful research for us, which is also accessible on AI, which is accessible on our website. Next, I would like to welcome Professor Benjamin White. He's at the Bournemouth University Center for Intellectual Property Policy and Management. He's a co-founder of Knowledge Rights 21 and Arcadia-funded project to promote copyright reform and open access in Europe. And he provides acts as an advisor for UK government's Intellectual Property Research Excellence Advisory Group. This is our excellent panel. And before I hand over the floor to Professor Christina Arian, I just wanted to share with you that this session is being recorded and will be available on the DTA website. Professor Christina.
Thank you so much, Deepika, for the introduction, and welcome to all of you, and welcome to my fellow panelists. Thank you for the Digital Trade Alliance for making this possible. Yeah, it's important to share knowledge around these new disciplines in digital trade and to understand better what their intentions are and how they are affecting our domestic regulatory frameworks, and what are maybe also the side effects that we are not seeing quite clearly on the surface. Today, we want to talk one more time about source code of software, which has arrived inside digital trade as one of the new let's say, desirable disciplines for digital trade chapters. And of course, most of you know that this is then going to be international public law and therefore binding on the parties of such a trade agreement. And the protection of source code of software has been inscribed now in a number of bilateral and also multilateral trade agreements. And is currently also negotiated as part of the GSI initiative on electronic commerce that is negotiated by now already 88 members of the WTO. So it's therefore something that is really going to happen, and that is disseminating rapidly. And there are two leading templates, I would say. One is the more European-leaning template, which protects the source code of software owned by a person of another party and against government disclosure and access requests. Yeah, that's the EU template, I would say. And then there's a more further reaching template that is advocated by a number of countries, among them vocally the US, but also Australia and New Zealand and Japan, for example, that wants to protect source code of software, and then also has the clarification that it says that also an algorithm expressed in that source code would be protected. So they say the word algorithm, the EU template kind of avoids it. Now, what is all driving us, the question is does that matter if you don't mention algorithm, or is it enough that such a discipline would protect source code of software against government access and disclosure requests? And then anyway, algorithms would be covered. And this is a debate that is real, because we had been trying to discuss that, for example, with the European Commission's DG Trade, and they always publicly stated that when they don't mention algorithms, then algorithms are not part of the game. Having said that, now we thought it may be really useful to invite technical experts, somebody who is versatile in data science, computer science, and the best person that we could possibly find is our fellow panelist, Joshua Tan, who is right now studying exactly this field, and he doesn't think like a policymaker or a lawmaker or a regulator. So he really can, I believe, authoritatively tell us whether source code of software covers algorithms or not. And we have then another contribution by Benjamin White, who is going to help us understand better why source code of software is such a new kid on the block, and how this kid basically relates to other existing protections that can also cover software. So we are having an interesting lineup. We keep it short. We will allow time for questions at the end. And I will now introduce myself and will show you why that matters, how digital trade law interrelates with the domestic regulation of countries. And of course, this is a very young field. There are not many domestic regulations at the moment that would require mandatory disclosure or access to a source code of software. But of course, this will also be more prevalent in the near future. And we have a nice example from the European Union's proposal for an Artificial Intelligence Act. So what I want to do is I want to show you now a very few slides with which I hope to share with you how the digital trade law discipline on source code of software affects domestic regulation. With some luck, you are going to see now my PowerPoint screen. Yeah, everybody can see it well. Now let's make that full screen, and I want to show you something about the practical relevance of this source code of software discipline and why we should keep an eye out for this. Already in 2021, the European Commission has published a proposal for the first legal framework on AI. The objective of this proposal is to promote trustworthy AI with a set of uniform rules targeted at developers and users of AI systems. And this should create conditions for AI development and uptake. This proposal is right now in the legislative procedure, which means it is not yet adopted into law, but it is going, or we expect that it will be adopted somewhere in this year, end of this year, or latest early next year. So in the EU, in the European Union, it is the European Parliament and the Council who will make this law and adopt this law, but the legislative competence to propose new legislation, that is with the European Commission. So it makes a lot of sense to look what the European Commission produces. And how do we change that now. Yeah. Here you see the article on confidentiality, which is right now in the legislative proposal for the AI Act. And you will see that source code is explicitly mentioned here. It basically is a new rule according to which authorities that are tasked with enforcing this new AI Act would have the chance to request source code of software, but then they also have specific obligations to keep this source code confidential. And normally in older legislative statutes and acts of the European Union, you would not find the word source code. They would normally only mention confidential commercial information or confidential business information, intellectual property rights, and sometimes they would also cite trade secrets of a natural or legal person. But that now source code is explicitly mentioned means that it is recognized that a source code is also protected by this legislative draft. It also means that sort of source code is also relevant in the context of AI, because we are talking about a proposal for an artificial intelligence act here at the European Union. So there must be a link with source code. Why source code is mentioned, we can find out with the help of a freedom of information request. I actually received these documents a couple of months ago already. And what you see here is excerpted, like just a small fragment of a letter that was sent between the Directorate General Trade to the unit of the European Commission that is making the draft for the AI Act. And this letter is dated from 9th April 2021. So it's a bit in the past, yeah, before the AI Act proposal was actually published. And here we see how these two different branches of the European Commission, one is doing the trade and the other one is making legislation, domestic regulation in that sense, are starting to talk with each other and trying to hammer out a position that is also in full compliance with existing trade commitments, and not only with existing ones, but also with prospective and future ones. And here we see that the trade branch is thanking the DG Connect, which is making the AI Act, for consulting it and for implementing a number of changes to the proposed AI Act. And there is a specific mentioning of source code commitments, and that this had have an impact on the wording in the AI Act. So we see that this really happens, it's taking place, it's not just fictional, but in a way these trade agreements that the European Union has already concluded has an impact on the making of new digital rules in the European Union. And here DG Trade is only citing the EU, UK, TCA, that is the trade and cooperation agreement that sorts the bilateral relationships, trade relationships of the EU and the UK after the Brexit. So one bilateral trade agreement is used in order to change the domestic regulatory framework of an entire bloc, which is the EU, with still 27 member states. Yeah? And we see that there has been language inscribed in order to bring the AI Act proposal in line with this source code clause now already binding with the EU, UK, TCA. Now let's look at a slide here that the Council of the European Union, which is a co-legislator together with the European Parliament, has published, and this I found on the State Watch website, which is continuously requesting access to documents from Council meetings. And here you see that the ongoing international negotiations related to source code protection have been cited as a reason to condition also the way how the AI Act can require access to source code for surveillance authorities. Yeah? And then we also find in the latest statement of the Council two more conditions that have been considered cumulatively before a regulatory authority that is tasked with holding artificial intelligence providers accountable can actually request access to source code. This is from the common statement of the Council, which is now the latest statement of how the Council, under what conditions the Council will support the legislative proposal of the AI Act. And here they say that access to source code must be necessary to assess the conformity of the high-risk AI system, and all other means such as auditing procedures and verifications based on data and documentation provided by the provider must have been already exhausted or proved insufficient. Yeah, so it's like last resort kind of regulation that we are seeing here. This is kind of self-binding provisions that tie the regulatory authorities to a number of difficult legal tests, potential liability, because a provider of AI can, of course, also make complaints against this source code request by the market authority, and it can also make it difficult to always prove that everything has been exhausted beforehand. So now we switch from the European Union to how the US Office of the United States Trade Representative is looking at the EU. Yeah, so in a way, the source code provision in digital trade law originates from a US template and has been taken up by various other countries in their bilateral and multilateral trade agreements. So it is already diffusing. But we want to see now how the US trade representative actually receives the Artificial Intelligence Act that is currently cooked up in the European Union. And here you find the 2023 report on foreign trade barriers, and they are having a nice quote on this proposal. The Commission proposed an Artificial Intelligence AI Act, and drafts of this AI Act require the disclosure of source code without strong, consistent, and transparent protection schemes for innovative and proprietary information embedded in the source code that is of particular economic value to small businesses. And this is the assessment from the US from 2023, so they must have also taken account of the additional mentioning of source code now in this confidentiality duty clause that I showed you initially. So they are not yet having. It is therefore something that is really happening. This protection of source code kind of jumps out of the trade law domain and lands inside domestic regulation. And for that reason, it is super important for us to understand what is actually meant by source code of software. And since we as lawyers and as policymakers are often not so deeply in the substance what computer scientists, data scientists, and other developers of AI think and how they are talking, it makes perfectly sense to have now Josh to introduce his study about the use of source code in the field of algorithms and AI.
Amazing. Thank you so much, Christina, for that lovely introduction. I am, as you said, definitely not a definitely not on the policy side, not a policymaker. But I can share a little bit in the next several slides. Let me see, put them up. Some little pieces of how technologists think about this work. Let me see, just okay, hope the slides work. Second. Okay. All right. So this presentation is well, it's mostly covers pretty much the same ground as in the recent publication, which is called How Code is Used. But I'll kind of summarize some of the main takeaways from the paper in this presentation, and hopefully that will give some context in which to have a further discussion as part of the panel. So right, I'm Josh. I'm at MedGov in Oxford. Because effectively some of the words I'm communicating as a computer scientist, to give you a little bit of background on myself. I'm a computer science PhD at Oxford. I specialize in something called applied category theory, as well as computational learning theory, which is a sort of subfield of AI. But I also do a lot of work on the governance of online communities. Previously, I was held fellowships at Stanford, MIT, Princeton, and Wharton. I'm the co-founder and executive director of MetaGov, which is a nonprofit research group that builds standards and infrastructure for digital self-governance. What that really means in this context is that I'm quite used to working with lawyers and policymakers, and even legislators on various topics. So I guess I was selected because of some of these communication skills. And just to clarify, I'm not what I think of as called the useful kind of computer scientist. I don't develop software, so I'm conversant and know how to do it. Like many computer scientists, I'm more of a mathematician. As you'll find in AI, this is also very much the case. Most people in AI are more on the mathematical side, in the abstract side, rather than building source code as a kind of regular profession. 3 takeaways from this talk. To regulate algorithms and source code, you really need to understand how they're used. And this will come out in the sort of later parts of the talk when we talk about all the different ways that source code is regulated. Second takeaway, trained AI models are clearly a form of source code. Given how important this is, as Christina highlighted, I just want to emphasize this. I can't emphasize this clearly enough. Like, to a computer scientist, it doesn't even make sense to ask the question. Of course, a trained AI model is a form of source code, because after all, it is just a set of instructions to a computer, and that's exactly what source code is. That said, there's all sorts of ways in which source code is, it's not, how do I say it? It's a sort of complicated phenomenon. Even if trained AI models from a computer science perspective are clearly a subset of source code, the meaning of source code itself is actually changing because computers themselves are changing. And I would say, especially because programming languages are evolving to become increasingly abstract. So there's some things are clear, other things are changing, and just like, it's good to understand like the sort of reality of some of these different interactions, at least to understand how technical the technical sort of community thinks about it. So quick outline of the remaining talk. I'll talk a little bit about how code is used, summarizing some of the basic use cases from the paper. I'll define then a simple model of how code is regulated, and then I'll dive into an example of how AI as a form of code is regulated. So how code is used. So code is used by software engineers in the sort of most basic fashion. Engineers, and I just the ones in bold are just the ones I'm going to kind of highlight here because I don't have enough time to cover everything. The point is, engineers obviously write code, and the key thing is that they use programming languages to write the code. If you're not already familiar with how this works, effectively, I write a set of, I think about them as like sort of very formalized structured sentences, almost the kind of things that lawyers write. And there's a programming language, which is basically a big complicated program that understands what I mean when I write that code and then converts it into binary, which is the literal instructions to a computer. At the end of the day, though, the point is source code is being used to define a set of instructions to a computer. In practice, engineers often structure that code into sort of libraries or modules. This is very important in terms of understanding how code is actually used in modern day structures. 99% of the code that an engineer uses in their software or in an AI is not actually, it's not something they code themselves. They import modules, they import code into their structures. And this becomes important as we think about how modern applications are built, and also how modern applications can be potentially regulated and controlled. And finally, a brief word that, this is kind of a similar idea. Not only code is structured into modules internally, but code is structured into these pre-written libraries, packages, and also API services which live offsite. Within computer science, which let's say, think of this as the more academic side of, or the more research and algorithm focused side of software engineering, really the key thing I want to sort of emphasize here to this audience is that computer scientists manipulate code as a form of data. And this has been going on for a long, long time, probably since really almost the beginning of computer science, and certainly from the beginning of the AI, that we manipulate code as a form of data, and we transform code into other code. And this is important because AI can be thought of as a series of manipulations of code. And the point is, this has been going on for a long time. And finally, within artificial intelligence itself, or when I think of this as AI kind of research as well as building. So AI engineers and researchers do deploy regular code to computers, like code that we agree is clearly source code, right? Then they also modify code by training AI models with data. So there's some sort of AI model, whatever you want to define by that, and they modify that through a series of procedures involving some form of data to sort of transform that code in a very similar way to what we mentioned earlier, in which computer scientists manipulate code as a form of data. In this case, it's just a different set of interactions. They're using data, and they're modifying the code in sort of like formal or structured way, some sort of algorithmic way. And lastly, just to make the point that we made earlier in the sort of software engineering slide, AI engineers also access and deploy pre-trained AI models. You can think of these as the analogs of these pre-written libraries, packages, and API services that normal software engineers use. So regulating code. So how am I doing on time? Okay, I should probably hurry up a little bit. So very briefly, this is a very basic, well, depending on how you look at it, somewhat simple model of how source code is regulated. Important point here is, though, that this includes not only all the laws and rules that we think of as entering into regulation, but all the ways in which an actual piece of code is affected by both like code-based things like the commit process and platform, as well as formal verification, how it's affected by norms within software engineering, like the particular development paradigm, like waterfall versus agile, as well as by market forces like users and presence or availability, or the trustworthiness of various external libraries and dependencies. I won't go too much on this, but I'm happy to sort of discuss this in the sort of Q&A part. And this is a sort of a simple model that takes the regulatory mechanisms, this simple model on the right, and then maps that against and relates it to the use cases that I discussed earlier. And the point of this relation with this diagram is to kind of illustrate, hey, if we're thinking about various forms of regulation, it's important to understand how code is actually used. This kind of like points it out in various cases. If I'm thinking about like legal employment and how that's used to sort of like shape the way that code works, I need to sort of understand that, okay, engineers use design algorithms to look out problems. That's similarly with computer scientists, right? It kind of goes into how we understand and how that regulatory mechanism works in controlling code. To give a quick example of this, I'll delve into just the one with this use case of AI engineers and researchers. And here, just pointing out that AI engineers and researchers access and deploy pre-trained AI models. What does this mean? And how does this impact these various regulatory mechanisms, including government regulation, legal ownership, IPR, trade secret law, development paradigms, commit process, and external boundaries and dependencies. So I might have to skip through this because I'm definitely taking way too much time. But from the regulation perspective, so if we try to take into account, like if I'm a regulator and I want to take into account the fact that AI engineers access and deploy pre-trained AI models, so the regulation may need to accommodate this fact, right? In particular, it might need to accommodate the fact that AI models can be used to train other AI models. So banning a particular AI model, I don't know, for some reason you might want to ban GPT 3.5, right? Might also mean banning all additional models trained on that model. So this might incorporate things like GPT-4, but also might incorporate things that are just like treating ChatGPT as more of a black box or a gray box, but are somehow like transferring learning from the AI model into this new AI model. Intellectual property rights, in this case, just basically also kind of reflecting on the fact that if I have a pre-trained AI model, this can be used to train or supplement, or even just generate data for another AI model, and licenses may need to kind of reflect these kinds of use cases. For trade secret law, well, I'm going to kind of skip this. On the development paradigm part, this is something that's a little bit more recent, but especially with the advent of large foundation models like ChatGPT, as well as Midjourney, Stability, it's just starting to change the development paradigm for how we build AI applications. So this is it's very interesting because this ultimately shapes, of course, the kind of code that is produced, as well as the different kinds of AI models and AI applications. And this is something that's really taking place at the level of different engineers thinking about how to use these different kinds of applications and resources. Another sort of like question, this is much more on the technical side, but if you're familiar with GitHub or Git, these are basically platforms that engineers use to practice a form of collaborative coding as well as version control on their systems. With these pre-trained AI models, that might actually need to change some of these versioning systems, as well as motivate improvements to these versioning systems, which would actually, as it sort of states here, go a long way to addressing some of the concerns related to both the uses and rights associated with these models. Essentially, what I'm saying here is that, based on there's a set of technical needs reflected in how we version control and sort of design the collaboration software for working with these large AI models. And if you understand how these systems work, you can actually embed or leverage them within certain kinds of regulation. Yeah, I think with that is the end of my slides. That was kind of a quick run through the paper and its main themes. I'm happy to answer questions.
Thank you, Joshua, and thank you for the excellent study. Again, the paper can be accessed on our website, and there's a link in the chat. Now I would like to welcome Benjamin White to make his presentation, and he'll be talking from the IP perspective.
Can you see my presentation?
Yes, you can see.
Yeah. Okay, let me maximize it. Yeah. So again, thank you very much to the Digital Trade Alliance for inviting me to speak today. And as discussed, I'll be speaking on the issue of intellectual property law, which, as Joshua highlighted very nicely, is one of the main legal areas that's traditionally sought to regulate software and algorithms. And this is not working. Let me go back. There we go. Although we see in trade law increasing sort of control over the conditions under which you can access source code and algorithms, this stands in in stark contrast, really, to I would say intellectual property theory, which traditionally has in trying to create a balance between users' rights to support economic innovation, deal with market failure, while protecting the rights of copyright owners and other intellectual property rights holders. Traditionally, we see a balance between access and control. And software is a particularly sort of interesting example of this, where although intellectual property rights protect software, in exceptions to these intellectual property rights and breaks on the intellectual property rights at the same time guarantees some forms of access. And I think I would argue that the increasing sort of control that we're seeing through free trade agreements, for example, is really distorting this balance that's traditionally we see in intellectual property law. So, for example, Christina talked about the GSI and the discussions are going on at the WTO. One of the founding treaties of the WTO is TRIPS, trade-related intellectual property laws. And that Article 9.2 states that copyright protection shall extend to expressions, but not to ideas, procedures, methods of operation, or mathematical concepts as such. And we can see that sort of distilled in European law, because an algorithm is essentially an idea. It's a recipe. It's how to do something. And in copyright law, as we can see there for the Computer Programs Directive, algorithms are left unprotected because copyright protects the expression, but it doesn't protect the underlying ideas. And that's why I think the developments that we see coming from the US, Japan, that's also pushing this, really the move to protect not the source code per se, but the underlying ideas of what's going on, what the software does, stands in sharp contrast to copyright and indeed trade secrets. I mean, trade secrets are, as they say, and it's very clear, they don't contribute much. There isn't much of a concept of balance, perhaps, between access and protection. But nevertheless, even in trade secret law, it's very clear that if you have access to, for example, software, then observation, study, disassembling what you have access to is lawful even under trade secrets law. So we have this sort of strong theme of the expression is protected, access is protected in the case of trade secrets, but once you have access, then the underlying ideas should be free for people to use. This is just a sort of a statement. The JSI, for example, going on at the WTO, which Christina referred to earlier, but this is, I think, my own sort of looking at the free trade agreements that I've been able to sort of discover that start to talk about source code initially and more recently algorithms. So essentially these source code disciplines, I think you can say, are spreading globally from agreements between a few countries, and in the case of the JSI, 80 plus countries at the WTO discussing how to protect in free trade like agreements access to source code and algorithms. I won't show that. That's Christina showed this earlier on, some of the text that indeed is seeking to protect access to source code and the underlying ideas of what's going on in the source code. So why has this happened? Well, one one of the main reasons is concern of let's call them AI exporters or technology exporters, that China has used the import procedures that it has as a way of accessing knowledge and ideas from companies that are wanting to export to China, which, zooming back, is actually one of the goals of TRIPS. Many of the developing countries, one of the reasons for signing TRIPS was actually the hope of technology transfer from the global north and developed countries to the global south. So in one part of the legal international environment, access to knowledge and knowledge transfer, access to source code and algorithms is encouraged. And yet now we see the opposite happening. So Joshua sort of touched on the use of the term source code as opposed to algorithm. Well, I would suggest that the reason that the term algorithm is being used as opposed to source code is exactly the point about access to the underlying ideas, principles, methods of operation, which copyright law leaves free, trade secret law leaves free once you've got access. So source code, the source code, the human readable code, is one thing, but actually what's going on here is trying to circumscribe access to actually the underlying ideas. Use of the source code could mean, if you're being crafty, that actually object code is left unprotected, or indeed other forms of copying, for example, on paper. And I think this is particularly important because given that in many technical products and services, the algorithms, the source code sits in the cloud, import into a country is actually the only point at which you may theoretically require access to the underlying source code and algorithms. And I think, it's very, very clear that countries like the US and Japan are not comfortable with this. Again, why now? Algorithms, I would say, are certainly weakly protected by copyright law, which was the main regulator of source code traditionally. The IP model there was based around procedural programming, where programmers were writing code, as we just heard from Joshua. 99% of the code is just used from pre-existing libraries. Therefore, protection of source code is, from a copyright perspective, is weak. So this is my final slide. So what are the ramifications of this? I'm particularly interested in the economic and development ramifications, that although traditionally knowledge transfer was encouraged by IP instruments like TRIPS, this is creating an atmosphere contrary to knowledge transfer, that actually access to source code and algorithms is something bad, that actually learning from others, how others do things, is something not to be encouraged. That essentially is a competition issue that the developing countries, the AI super states, as they're called, who are the main exporters of technology and AI, are wanting to create an atmosphere, a legally binding regime where knowledge transfer and access to ideas which allow you to develop your own competing products and services is not something to be encouraged. And I think it's very clear that we are moving very rapidly away from this sort of IP-driven view of the world, where access to certain things should be free and encouraged for competition reasons, to a world where certainly the exporters of these AI technologies are not wanting any form of competition and wanting to keep their own ideas away from potential competition. I co-authored an article recently, which I need to get on SSRN. I haven't actually got the PDF yet, but myself and my colleague Maurizio Borghi wrote a book chapter on exactly this issue of free trade agreements, looking at it from the perspective of predominantly copyright law. So thank you very much.
Thank you, Benjamin. Thank you for that presentation. Now I would like to welcome Professor Christina and Benjamin to do a Q&A with Josh. Thank you.
Thank you so much. This was really two great presentations, and I already see how we use the terms a bit differently. Yeah? I start with you, Josh, because I would like to know something. You have touched upon that there is a lot of libraries and source code that is reused and basically plugged in into technology and then that generates something new. Yeah. And I also believe I read that there is a great tradition in this AI field to still produce open source algorithms and open source models, yeah, algorithmic models. And when I now see what this digital trade agenda is doing, then I believe it's actually already starting to show the decline of the idea of open source. Is that true, that there's now less open source than there used to be?
I think it's not less in an absolute sense, right? But I think relative to where, let's say, market power, like OpenAI doesn't open source their models, right? And this is obviously like hugely problematic, given the potential importance of these larger models. The honestly, this is something like people in the technology side are very, very sort of like concerned and kind of interested in. Around how we can effectively promote more open source alternatives. Like, for example, Stability AI is like leading some of this work in producing and open sourcing their models. But obviously, you know, to do that, they need to develop certain kinds of new economic models to support that, which could be potentially supported with, new legal models as well, new regulatory models to support and promote more open source development, which would perhaps counteract some of the things that Benjamin was noting, this fortification of AI superstates, right?
Yeah.
Yeah, certainly from a normative side, like my intuitive sense, and like almost everybody like on the CI side, thinks of like the core thing behind like all these AI is a set of public algorithms that is essentially just mathematics. And the thing that we're not seeing is just that there's like a huge amount of engineering that goes into deploying these like really large models. That's the stuff that's hidden away.
Awesome. I also figured from when I was listening to both of you that an algorithm can be different things. One algorithm can be in different states, let's say, at the same time, right? There is this conceptual idea that the idea what the concept of the algorithm that is not yet coded in source code. This idea in itself would not be deserving protection under the common, let's say, intellectual property law regime. Then we have the source code. Yeah, that's when this idea of the algorithm is really then expressed in source code. In that moment, it would potentially deserve some protections. And then we have the object code, which is in itself not protected, but it is what eventually then also instructs the computer. The source code and the object code are two different things, as we know from software studies already. So in a way, I think this is hugely confusing. My question would be now to you, Josh. I know that not every code today is anymore hand-coded using languages, computer languages that are like human understandable. I know that these like self-learning AI, typically they instruct themselves, by using more data to learn from. So my question to you is it then, do we still then talk of source code?
Yes. I was actually having a long, fun conversation with some lawyers about this recently. And I guess like my contention, and this is hypothesis, right? Even from a sort of, it's certainly not like a well understood sort of thing within CS, is that yes, programming languages are becoming more abstract. Python, for example, like one of the most popular ones, is like already like a lot of things you write in Python, like sometimes look kind of like natural language sentences. They're like designed to be easy to parse, right? So we can understand the intention or the meaning or the sort of like the action of the code. And we're getting to the point, of course, where, I was going through this exercise recently of you can essentially pair program with, ChatGPT or with GitHub Copilot, right? And it'll produce code for you. You write in natural language, it produces code for you. And ultimately, you can imagine that eventually just like executing this directly. My sense, though, is that, the thing about ChatGPT is it's at the end of the day still a statistical program. So there's always a chance that, it delivers something very different, right? And I think that I would put it there. There's like, source code is things which have like a absolutely definitive, action that like, if you put it in, it is deterministically the case that this will always happen. Like if I write this code, these behaviors at the end of the day in this computer will happen, assuming that the computer is like, like a well-modeled Turing machine of some sort. So that's kind of like the thing I would say, and that puts an upper bound, I would say, on the kind of what we sort of recognize as source code. This is more speculative, but I think like one of the most interesting things is you can imagine statistical programming languages, being created to reflect this like new ability of code to produce source code, but that would require like a different regulatory paradigm entirely, I think, and we're not there yet.
Right. I think we have a couple of minutes and we should maybe take account of other questions that we get from the chat. And I have one copied here. We have a question from Daniel. Thank you, Daniel. Understanding the nuances, whether he thinks, I assume it's you, Josh, yeah? Whether he thinks there is a legitimate justification for drawing the parameters of AI regulation through trade agreements as opposed to domestic legislature. Could be also a question for Ben, I think.
Yeah. So a long time ago, I don't know if this is worth sharing. I'll copy the link at some point later on in the chat. I wrote a paper discussing how basically recognizing that there are like these like AI races that are happening, both at the level of like kind of like the free market between like, effectively Google and Microsoft, but also between nation states, right? As Benjamin pointed out. And there's a question of like, how do you implement industrial, like competition policy or industrial organization in these settings? Especially since like there's no really well-defined like market per se for AI goods and services. It's like not like a conglomerate, like integrated thing. And that's one of the interesting things about ChatGPT, that is actually integrating a lot of different markets into one thing, right? A lots of different services into a kind of one service, one application effectively. But as we think about like sort of the way we define these markets, I think it's that's one of the, I think, like mechanisms and maybe like best mechanisms for shaping and controlling these race dynamics within AI. In which case, I would argue that trade law has maybe even a more important role than the actions of domestic legislatures, because it can help us think about like, how do we define like these different sort of market structures? How do we like perhaps break up certain markets or further integrate certain markets in order to facilitate, let's say, more decentralized or open source approaches?
Yeah, I'm a bit worried that we have not yet thought that through completely, because as Benjamin's presentation showed, we are creating overlapping regimes here. And with that, Benjamin, you want to comment?
Yes, I guess I was just wanting to riff off what Joshua said there. I think I think the question is it a legitimate area for free trade agreements? You know, it's realpolitik. What's going on here are the exporters of AI technologies, you know, primarily the United States and countries like Japan, who are very strong in terms of driverless cars and robotics and other IoT type technologies. It's these countries that are wanting to export, you know, being simplistic, China's main market is its home market, so less interested in this. But what we're seeing here is the exporters wanting to keep their dominant position. And I think what is interesting is that you know, it's not a global north versus global south debate. It's a US, a few East Asian countries versus the rest of the world debate. You know, Europe is a clear laggard in this space. You know, all metrics show that Europe is way behind other countries. And I think kind of the sooner this is realized, discussed, the better. And I shall shut up now.
Right, that's well put. I would like to actually flag another risk for me that I'm seeing, and that is originally IP protection and also trade secrets have been used to fend off competitors, to get exclusivity for a while, to exploit your innovation and so on. And the way how the source code discipline is now framed, that it is actually dealing with or trying to limit government's ability to require access and disclosure of source code of software, we actually see how this moves inside regulation, right? And inside regulation, it will actually become a headache for regulators to deal with this in this way. Regulators are pretty well accustomed to, let's say, commercial business secrets and this type of existing categories. But instead of fitting it inside there, we are getting now an additional category, source code of software. And this is something that is maybe not justified. Maybe it should be put inside the existing categories of commercially confidential information that have always been around. Yeah, and I'm worried, of course, about turning open source software into something that is suddenly protected in the regulatory process. So, but I believe that thanks to the paper Josh has drafted, we have now always a source to point to when somebody says that source code of software has nothing to do with algorithm. And this is going to be a wonderful thing, because we can like put it under our arms, and whenever this comes again, this argument, we can say, no, but Josh says, and he knows. So I want to leave it here unless we have other questions. Right.
We don't have any other questions.
Then we should probably wind down.
Yeah, I think the panel was supposed to end at the hour, right? So people maybe need to go back to the other meetings.
So I would like to, first of all, thank you, our panelists, for such a great discussion. Thank you, Joshua. Thank you, Christina, and thank you, Benjamin. I would like to thank our participants who participated in today's discussion. We look forward to seeing you in our next DTA webinar event. And once again, the session has been recorded and will be accessible on DTA website. Thank you.